Okay, welcome everybody. Thanks for joining today. I assume everybody's or a bunch of people have joined so far. I can't really tell in this current screen, but I'm assuming everybody's joined or most people have joined. Today's topic is going to be M&A letters of intent. This is a great topic. It's one of my favorite topics because it's the kickoff to an M&A deal, which is our favorite type of transaction here at Trevor Crow Legal. So just a quick background about us. Trevor Crow Legal, we're an 8-attorney firm here in Denver, and we focus on mid-market deals, which I'm categorizing as deals within the $1 to $50 million range. And that's kind of the context that I'm coming at with these M&A letters of intent. Obviously, there's letters of intent for deals that are much larger and deals that are much smaller, and those may be different, but our experience is in that $1 to $50 million range. And so that's where I'm going to be focusing my experience comes from, and a lot of the comments that I'm giving is in that context. As I mentioned, Trevor Crow Legal, we're 8 attorneys focused on mid-market M&A deals, representing both buyers and sellers. We also do, entity work for companies raising money and securities offerings, but a big portion of what we do is M&A deals, and so this is why this topic is so important, I think, and then also fun for us to talk about, because like I said, it kind of kicks off an M&A deal. So let's go ahead and get started. I don't want to spend too much time on my background because we have 30 minutes to get through several different slides here, and then also leave time to answer questions. If you do have questions, please put it in the chat. Jenny, our intake specialist, is on right now, and Jenny, I'll say that I don't see the chat for some reason right now, and so if something comes up, let me know. But for now, we'll just keep going. We can if you enter in those chats, we'll find a way to respond to it. So please put any questions you have in the chat. All right, let's get started. So first off, I'm talking about the agenda here. We're going to talk about the purpose of letters of intent. Negotiating a letter of intent, also called an LOI for short. Talk about the non-binding provisions. We'll talk about the binding provisions. I have a specific slide here on just working capital targets, because that is where I see a lot of issues that come up on LOIs, and people who are, when we're negotiating those, there's often a problem with that working capital target, and how do you negotiate that? How do you get that into the agreement? So we'll spend some time there. And then we'll talk about potential pitfalls with LOIs. So that's the agenda. Let's go ahead and jump right in. Okay, so purpose of an LOI. So this is typically the first document negotiated by the parties in a letter of intent, is the letter of intent, and it's really just a written expression of the party's intent to enter into a transaction, right? So it has a summary of material terms. And the reason for this, or the purpose behind it, is because negotiating and documenting an M&A transaction is time consuming. Doing the due diligence is time consuming, and it's costly to both the seller and the buyer to go through this whole process, right? And so you don't want to go ahead and do that whole process of due diligence and then find, when you start to document the transaction, that you guys the seller and buyer aren't in agreement on the major terms. So the purpose of the LOI is to kind of highlight what those major terms are that the parties are agreeing to, and it allows the parties really to determine a process for the M&A process, right? So they kind of lays out how that's going to work, and really, in my mind, it's the place where you want to put your deal breaker issues. So you want to have all your deal breaker issues in a letter of intent, just to make sure that the parties are in agreement on these deal breaker issues, so that when you move forward with due diligence and other things, that you're going to have a potential agreement, subject to confirmatory due diligence. Now, I broke this out in bullet points here because I think the purpose is different for the seller and the buyer in a lot of ways. The first bullet point for each, as you'll see, is to agree in advance on material terms. Although in the buyer section, I said subject to confirmatory due diligence, right? So, the seller wants to know that the purchase price and terms are on something that they're willing to accept to sell their business. The buyer is saying, here's what I'm willing to offer for your business, subject to me doing due diligence and confirming what you've already told me, if anything, right? So that's a little bit different there on who, the purpose for the buyer and the seller. On the seller side, you want to enter into and confirm confidentiality agreement. So, I mentioned that the LOI is typically the first agreement that's entered into, although what may have preceded that is a NDA or a confidentiality agreement. And sometimes that's necessary to give the buyer just a teaser of information out there, right? So a lot of times these businesses are offered for sale on websites or marketing materials or direct communication with brokers, business brokers or investment bankers. And usually there's some sort of teaser information, right? Like, hey, it's a manufacturing company. It's doing this much EBITDA. It's doing this much SDE. It's located in this geographic region type thing. And so sometimes that's the initial sort of teaser on the marketing or advertising. And then, before an LOI is submitted, that buyer may even want some more detailed information, not everything, but a little bit more information on the business. And in which case, oftentimes there's going to be a confidentiality agreement or an NDA that's entered into, so they can get just a little bit more information before they make the LOI or put together an LOI to make an offer for the business. And then last thing on the seller side is to create an outline for the process and closing. You'll oftentimes there's, hey, we're going to close this in 60 days, 90 days, or we have a target closing date of, X in there. And so that's obviously important to the seller because they want to know when the deal would close if everything works out. On the buyer side, we already discussed the agree in advance on material terms. So that's definitely one of the main purposes. It's also, again, subject to their confirmatory due diligence. So they want to make sure that what they've seen so far, they can confirm through their further due diligence. And so that's a big piece for a buyer. But you have a couple other things here. One is to lock up the business with exclusivity. So that's a buyer favorable term in an LOI. And the reason for that is they want to have exclusivity while they're doing due diligence. I've already mentioned that the M&A process is expensive and time consuming. The buyer does not want to make an offer at a purchase price and terms that the seller is willing to accept, and then spend all the time and money on the due diligence process, and then later have the deal pulled because the seller gets another offer for $1,000 more or something like that. And so to avoid that, usually there's a term in the LOI that provides for exclusivity. So that says that seller is not going to continue to market the business for sale to other people or accept any offer to buy the business while this term sheet is in effect. And then the last one is same for buyer and seller, is that to create that outline for process of the M&A deal and for setting a time for closing. So we're going to get into the next slide on negotiating the terms of the LOI, and we're going to also get into the binding and a little more detail on the non-binding and binding terms. And I'll say, sometimes a question comes up is, why do we even care if it's non-binding? And the reason to care, I think, is because it does create a moral obligation as a practical matter. It sets expectations for the parties, and so any deviations from those terms that are in the LOI, even though they are non-binding, is going to be seen as a retrade. And so you don't necessarily, it doesn't really, it's not a good negotiation position to, put out something and then try to retrade it later, right? Because that's going to be off-putting to the seller, and certainly to the buyer. It usually goes from the buyer trying to retrade on the seller as opposed to the opposite. But I guess it could go both ways. Either way, this kind of sets a moral obligation or at least an expectation on what the terms are going to be. And so if there's just a random retrade on the terms, then that's going to be an issue in negotiating the actual deal documents later. All right, let's go to the next slide here. We have negotiating an LOI. So, I always say that negotiating an LOI is going to be an art, not a science. And so you got to balance the negotiating position. And, pre-LOI, I would say in general, the bargaining power is in the seller's court, right? Seller has can accept or reject any LOI that comes to them. And so they really want to make sure that they're figuring out what exactly they want, at the end of the day, what they need to retire, what they're willing to sell the business for, which could, include thoughts or considerations such as what do I need to retire if they're selling the business and retiring afterwards. And also what's realistic, right? You can't just say I need this to retire, but the business isn't worth half that. It's not going to be realistic to try to ask for that price. So I would say, in general, you want to take your time with LOIs to the best you can, and just know that when I say art or science, is the less precise the LOI is, the less detailed it is, the more you're going to have for potential renegotiation by the buyer on one side or additional terms that aren't included in that LOI. And it usually makes that process for documenting the transaction and the definitive agreements, the actual asset purchase agreement, more difficult because there's less terms that were pre-agreed to in the LOI. But at the same time, again, while I can't say, it's always better to have a detailed LOI versus a more general LOI, is because sometimes you just want to get it locked up and move down the road on due diligence. And sometimes you also don't want to, on both parties' side, is if you spend too much time on the LOI process, it can certainly lead to deal fatigue before you even get started, and before anybody's really committed to the deal. Once you've gone down the process of due diligence and things like that, both parties become more committed to the deal, and so they're more willing to negotiate on those terms and actually stick it out and get through the hard pieces of an M&A deal, as opposed to in the beginning, it's where it's easy just to reject the LOI and say, we'll wait for the next one. So definitely an art there on how much detail to put into one and what makes most sense based on the seller's demeanor, the buyer's demeanor, and how we can get the deal going so that people feel more committed to work through the hard pieces of it. The balance of power, going back to that quickly, I think the balance of power is in the seller in the beginning. Once there's a signed LOI and there's exclusivity, then the balance of power, in my mind, shifts to the buyer in that case, and because the buyer has exclusivity or should in the LOI, where it says, hey, we're not going to market to this to anybody else. So they're kind of committing to this buyer and through the due diligence process until the term of that LOI expires or that exclusivity provision expires. As a general rule, I'd say you want to include your deal breaker terms in there. That's the main purpose of an LOI, is to have those deal breaker terms in there so that that you're not spending time and money on due diligence and trying to get the transaction closed if there's certain items that aren't going to work for either side, right? So buyer should have its deal breaker terms in there, and seller should have its deal breaker terms in there to make sure that doesn't come up later. Include deadlines. That's another tip I would say. You want to include deadlines for things. How long is due diligence going to last? When is closing going to happen? When might the buyer might be able to meet key management if that's something that's negotiated in there. So that's all things to think about. And then take your time if possible, which I've already kind of mentioned. You want to take your time to make sure that you got the LOI done correctly and again has all your deal breaker terms, because afterwards it's going to be hard to renegotiate those terms. And so you want to take your time, but as I say in the slide, then work quickly, because as soon as that LOI is signed, you want to be ready to work quickly on due diligence to keep the process moving, because time kills deals. And so you want to definitely keep things moving as soon as that LOI is signed. One other thing in negotiating the LOI, or a couple other things, I guess I would say. One is potential liability. You want to make sure that it's non-binding. So there's non-binding, and there are some binding provisions, but the deal terms, and for most of this LOI, you want to make sure that it's expressly stated in that LOI that it's non-binding and it's subject to entering into definitive deal documents. That should be clear and unambiguous in that LOI. And because the problem is if you have a detailed LOI and you don't have the provisions in there like that, it could be deemed a contract. And I think it's rare in the mid-market for that sort of thing to happen. But there's case law that comes out of Delaware every year on big cases, on big merger and acquisition deals, where a LOI is trying to be interpreted as a contract to actually close. So certainly you want to have that expressed in there. And also, I would say I've noticed in some cases you have things that are say it's an LOI, and so the thought is it's titled LOI at the top, but if you actually read through it, it's not really an expression that it's non-binding. It's more of a purchase contract. And so I've seen that a couple times. I had a potential client who came in, said, "Hey, I signed this LOI," and they sent it to me, and is prepared by a broker, and I read through it and said, this is not an LOI, this is a purchase agreement. And because it had all the terms. It said, you're buying and you're selling, and it's effective as of the closing or as of signing this. And so it was a strange situation. I think it was more of a mistake, but again, it's just something to make sure that you're actually reading this and not thinking, hey, it's non-binding, so I don't need to worry about it. Let's see here. Oftentimes you are working with advisors for this, like I said, business brokers or investment bankers. And so, a lot of times an LOI could be coming from them, or a form at least. And so again, just make sure that, which is helpful. And so I'm not saying that's a bad thing. I'm just saying you want to still make sure that you're actually reading through it and understanding it, and either having a lawyer help you with that, or if you've dealt with a lot of LOIs, then it might be something you can handle. But certainly it's something that we deal with a lot, helping people form and craft their LOIs before signing. But sometimes we do get deals that come in and the LOI is already signed. And so we can help with that too. All right, let's move on here. All right, so non-binding provisions. These are typically the non-binding provisions of an LOI. So you have at the basic level, you have the structure of the transaction. Is it going to be a asset deal? Is it going to be a stock deal? Is it going to be a merger? And so that has significant implications on the tax treatment and the closing mechanics of a deal. And so you really want to have that in there. If there's going to be rollover equity from the current owners, things like that, you would definitely want to have that in there. Next is the purchase price and terms. And obviously, this is another big reason or big thing that's included on almost every LOI. It's going to be the purchase price and terms of the purchase price. So that's what the seller's looking for. What are you offering to buy this business for? And so that's usually expressed in there. I would say the terms should be, if they can be determined, it should be expressed in there as well. How much of that purchase price comes at closing? Is there going to be an escrow? Is there going to be a seller note? All that, should be detailed in the LOI if possible. In indemnification framework, often an LOI is going to have a summary of the expectations on the non-financial terms of that purchase agreement. Things like indemnification, how's that work? Is there going to be baskets? Is there going to be caps on indemnification? How long does the reps and warranties survive? Things like that. There might be that included. Key closing conditions. This is often included, not always, I would say, but things like, all right, we got to, we have to have a non-compete entered into. We have to have a assignment of the lease or a new lease entered into with the landlord. All those sort of things that are key issues that need to be solved prior to closing. A lot of times those are included in the LOI. Next is management arrangements and non-compete. So I kind of already addressed the non-compete, but management arrangements are going to be, is there any key employees that you need to keep on that need to enter into management agreements? Is the seller going to stick around and provide transition services? You might want to have some provisions on that. How long they're going to stick around? Is it part of the purchase price? Or they're going to be paid? Oh, I do have the Q&A here. Gosh, this is working. Could you please mention a few deal breakers to include in an LOI? Thanks, Greg. All right. Good friend, Greg. Great question. Deal breaker terms, I think, are, you know what, Greg, I'm going to get to that question, and I'm going to get to that into the potential pitfall slide. And so I'm going to get to that in a second. Regarding structure, asset versus stock, what if there are complexities that make it unclear? If it should be an asset versus stock transaction at any time, at the time of the LOI, needs more attorney due diligence. Okay, great. Great question as well. And I guess I will say this just as a general comment and a caveat to everything I'm saying here is this is what makes it an art versus a science type thing. Is if you don't know and you want to get the business locked up and you think you need more due diligence that you're not going to get until you have a signed LOI, then you can make any of these more broad and subject to more due diligence. So I've seen LOIs where it says, hey, it's going to be a transaction, either asset or stock transaction, depending on further due diligence. Could be as vague as that, or it could be it's going to be an asset or stock transaction, depending on assignment of contract issues, or you could have more detail on there. You might have different things on how the tax is going to work, because buying assets and getting step up in basis, you might offer a different purchase price versus if you're buying stock and you don't get that step up in basis, and the seller's getting all capital gain for that, as opposed to the typical allocation among the assets. And so anyway, there's definitely ways to do that. And so any of these things can be based on the information known at the time of entering into it, can be put in there and structured as more vague. So again, you could have it be as vague as that. And I've seen that. We had a deal recently actually where we said we anticipate it to be a stock transaction based on the anti-assignment provisions, which we've been told, we were representing the buyer in this case, which we've been told are not assignable on some very large contracts, government contracts, or it would just be a very difficult bureaucracy to wade through to try to get those assigned in an asset purchase type deal. So we said, subject to additional due diligence, we were going to structure it as a stock deal, but if there was a way to assign those contracts, then we may switch it back to an asset deal. And we had some provisions in there about the purchase price would be grossed up or down depending on which one it goes, which way it's structured. So certainly something that you can do there. Another question, Jonathan, I also have a question about exclusivity and good faith negotiations. How often do you see good faith language where the seller agrees to cover costs if they negotiate with another seller in bad faith during the exclusivity period? That's a good question. I would say I don't see that very often. I think that's would be a great provision to have on the buy side. But typically, you don't. What you would have is, if the exclusivity is a binding provision and they've breached that provision by going out and talking to other potential buyers, and you're damaged by that, which is, hey, now they're caving our deal and going with the new potential buyer because they've been marketing it, then you would have a breach of contract and damages claim. So you would have to sue them. Now, so if you really wanted to have that sort of good faith and a real hammer, you would want to have some, potentially even put that money in escrow on the seller, that, hey, we're going to put this money in escrow and it gets released to me if you go out and you breach this provision. I think that's going to be very hard to get. In very large deals, there are things like breakup provisions and things like that, and that money's put into escrow, and if the deal doesn't close, they get the buyer can get the breakup fee. I would say it just doesn't happen very often in mid-market M&A deals that I'm involved with, at least. I think it'd be a hard sell and hard to get. Not saying it's impossible, but I think that would be hard. And at most, what you would have is just a breach of contract claim, because I don't think many sellers are going to be willing to put up any money in an escrow account. It's going to really just be hey, you agreed to exclusivity, you breached that. That's a binding provision in the LOI, and you breached it, so I'm going to sue you for breach of contract. It would have to be, the problem with that in my mind is that it's the litigation piece may be not worth the squeeze. In other words, paying for attorneys to litigate that issue unless they can just agree to a settlement quickly might not be worth the damages that you have. Again, depending on the size of the deal and how much cost that you put into it. So anyway, that's my take on that. Another question, how do you handle working capital? Is that part of the price and terms? Yes. So we have a whole slide on working capital, and we'll move quickly through that. I know, gosh, I should have put this presentation for longer than 30 minutes because we're already 25 minutes in, but I'll keep going, honestly, past this 30 minutes, and we'll try to get through all this if everybody's willing to stick on. So, but we'll talk about working capital on a later slide. All right, moving on to the next thing, we have due diligence. A letter of intent often describes the scope of the buyer's proposed due diligence, and so that's going to be where you want to have sort of an outline on how the due diligence process is going to go. All right, next slide. Binding provisions. So these are the binding provisions. Let's see. All right, another question. Is it typical to have language in an LOI that the seller pays all the buyer's legal fees? I don't see that as typical, no. And I assume that question is asked in the context of if they breach the exclusivity covenant in the LOI that is binding. That I would say I don't often see that. Usually what we'll get into here is on these binding provisions is usually there's a specific provision that says each party is entitled is required to pay their own expenses. So any expenses that you've incurred for due diligence is buyer's responsibility. Any expenses that the seller has incurred for negotiating the LOI or providing due diligence materials or anything like that is going to be theirs. Any regulatory filing fees, things like that, broker fees, if they are applicable, those are all, everybody pays their own expenses. And so that's typically in there. I guess if you did have a provision, you could have a provision in there that said if there is a breach of the exclusivity that you're going to pay your legal fees. But I would say that's part of the, that would be included in what you're saying is you're damaged, if somebody breaches the exclusivity or if a seller breaches the exclusivity covenant in the LOI. All right. So here's the binding provisions. Exclusivity, we've talked about that, and that's going to say, hey, we're going to take this business off the market and not going to market to other people during the due diligence process once we've signed the LOI. Usually there's a period for that, so it's not indefinitely. It's, hey, we're going to give you 60 days, we're going to give you 90 days, and that exclusivity. The need for that exclusivity goes away once you have a purchase agreement signed. So it could be even less. It could be, hey, we're going to enter into an exclusivity for 30 days with the expectation that we enter into a definitive asset purchase agreement within that 30-day period. Because the purchase agreement, once that's signed, there's no going back. It'll have exclusivity in there. It'll say that, here's the closing conditions, and you have to work, everybody's working in good faith to meet those closing conditions and close on these terms. And so really that's once that's signed, the LOI exclusivity is not meaningful anymore. And so there's no real need for it. So anyway, there's a number of ways you could structure that. Confidentiality, this can be either saying an actual covenant for confidentiality, saying that the parties agree that everything is confidential. It could be one-sided or it could be mutual. If there's going to be a seller note and the seller or the buyer is providing financials and things like that to the seller just to show that it has, the ability to potentially repay a seller note, then it might be mutual. But more often than not, what the LOI does is it just references the NDA that the parties have already entered into, right? To get some additional, usually there's some additional information that's been provided to the buyer. And so before that happens, like the name of the seller and some more detailed financials, potentially, there's usually an NDA or a confidentiality agreement that's been entered into. And so in that case, the LOI just really says, hey, all parties are recognizing that that's been entered into, and it will continue to be entered into or continue to be binding on all parties, right? All right, then governing law obviously is another one that's usually in there, and that's just saying, hey, this LOI and the binding provisions are governed by XYZ, Colorado state law, for example, or wherever it is, Delaware law or something like that. All right, follow-up question. How often do you see earnest money as part of the LMM or Main Street deals? Buyers have hard costs and DD and should suffice for skin in the game. Yeah, this is one of my, honestly, pet peeves is when there's an LOI and the seller's asking for earnest money up front. And I think it's a lot of times it's because, maybe there's a broker involved who's mainly been a real estate broker in the past where earnest money is done, where earnest money is common practice. this is not, in my mind, it's not a real estate deal, right? You can't compare it to a real estate deal in that there's a lot more due diligence that's involved in it. That's not just, hey, here's the property and is there any environmental concerns, or can we get past the inspection period type thing? And so, putting up earnest money in my mind is a red flag. And I just think it's worthless, because it should be, the way it's structured should be worthless, in that even if I put up earnest money, it should be totally refundable for almost anything that I find in due diligence, or for anything I find in due diligence, honestly. And that due diligence period should be once you get basically to closing, because things can pop up all the way up until closing. So, hey, we find something else, and there should be a duty to disclose any issues that come up prior to closing. A material adverse effect in the business, for example, is usually a condition to closing that there has been no material adverse effect. So if that happens, I should get my earnest money back. And so anyway, I just don't think I agree that the due diligence should be considered skin in the game, and that the earnest money should not be there. I think there's other ways to prove that the buyer is committed and has the funds to close. I mean, obviously they might need financing, so they may not have all the funds, but they are set up in a way that they can close. But I'll get into that real quick. But first, we got another one that's been very helpful. I have to drop. Yes, we will be sharing this presentation. It's being recorded, and so we will share this. So thanks, Christian, for joining, and have a good day. So on the back to this real quick, how do you get skin in the game, or how do you show that? I think you can even put deadlines in that LOI to say, hey, within a certain number of days, we're going to show a commitment from a lender that they're willing to lend on this business. Within X number of days, you can tier this exclusivity just to make sure that the buyer is working and has skin in the game, and you as seller, you're not losing out on much, because that exclusivity period is kind of tiered. And here's some milestones that you need to meet before. We got to get an asset purchase agreement signed by this date. We got to have a commitment from an SBA lender by this date. Those sort of things you can do to show skin in the game, and also improve the chances of the deal closing, and feel good about it without having earnest money. And so that's my take on it. All right. Next, working capital targets. So let's see here. Working capital. Okay, so yeah, working capital targets. These are important, and I think something to think about when you're putting together an LOI is there going to be working capital, and so not all deals have that, right? Sometimes it's debt on a cash-free, debt-free basis. It's just a strictly asset sale, and there's no talk about working capital. But this is, again, where I've seen the most issues later, is when we've had working capital provisions and they're not well defined, or it could even be a big issue, negotiating the LOI up front. A lot of times sellers aren't familiar with this concept. And so it's the thought is, why would this be in here? What does this mean? And so, the typical definition of working capital is current assets minus current liabilities. And usually there's a target, because when you're buying a business, you're buying it as a going concern. And so you have a target for what you want to be left in the business. And so current assets minus current liabilities, a lot of the current assets are going to be, accounts receivable, cash, things like that. A lot of time cash is excluded from that definition. And we're just saying, all right, accounts receivable, going forward, this is how much accounts receivable you're going to have, because I've determined my purchase price as a buyer potentially off of what, how much is being able to operate the business as a going concern moving forward. And so if all accounts receivable is taken out, all current assets, and you still have these current liabilities, when you step in, how are you going to pay for those, right? And so coming up with that and figuring that out is a big thing. I don't think we have time to really get into too much on how working capital works, but I would say that this is something to definitely spend some time on. Make sure you have an idea. And also, this is one of those ones that, like the question earlier about, hey, what if you don't know if it's a stock or asset deal in the beginning, because there's other due diligence that needs to happen. This is one of those ones where a lot of times there has to be more due diligence to say, hey, or what is the historic working capital? Might be a consideration, right? But it also, from a sell side, you might want to say, hey, it's not just what historic working capital is, because some businesses keep too much cash in the business. For example, they keep too much in there and without distributing it out. And so you might have historically a much larger working capital than is really necessary for the business. So it's kind of coming up with what is necessary for the continued operation of the business as a going concern. Potential pitfalls is next. And so here's kind of this exclusivity thing. I think I've noticed this recently, where a lot of times the exclusivity is not really exclusivity. It says we won't accept another offer, but we're going to continue to take offers. We're going to leave the posting out there and marketing it and that sort of thing. And I think that's a tough one to have in there. And because as soon as there's so many ways to cave a deal, and if the buyer's out there collecting offers and they get one that's $5,000 more, there might be a big incentive or a $5,000 incentive to cave the deal and work with that. Try to find go with the other buyer. And so anyway, I've noticed that recently, that there's been a lot of LOIs that I've seen where it said exclusivity was limited and said, we won't accept another offer, but we're going to continue to collect offers. And I think that's a red flag for a buyer, in my mind. Unrealistic due diligence timelines. I think this is sometimes a pitfall. Obviously everybody wants to get the deal done, but some things take some time. And so in a lot of times, everything's not ready. You sign the LOI and you say, all right, here's my due diligence checklist, for example, and it takes 3 weeks to get all that information. Now, I know there's a lot of great brokers out there, including some on this call that I know that are, they come to the table and they're ready to go. They got that data room ready. They got all the due diligence materials and things like that ready to go. And in those cases, I think a shortened due diligence timeline is appropriate. But if that's not the case, then you got to really think through how much time you're going to need to do due diligence. Another pitfall is failure to anticipate financing terms. I can't tell you how many times I've seen, and this, Greg, this goes back to your question on deal breaker terms. I've seen this as deal breakers often, is where, hey, here's the purchase price here. There's going to be a seller note, and it just says the seller note of X, and we're going to get SBA funding, and then it doesn't come out until later that seller note is going to be on full standby for whatever 10 years, and subordinated to that SBA loan. And so sellers hear that after an LOI is signed, and they're like, oh, wow, that's not what I agreed to, or not what I anticipated. Again, having good brokers and advisors involved can help make sure that issue is addressed in the LOI, or at least known by the seller at the time. But I think failing to anticipate those financing terms are big. Having that, it should be a condition to closing, right? That, hey, we need to be able to obtain financing. Sometimes the bank's going to take a look at the financials and say, we can't finance it at the purchase price. And so, that really should be a condition to closing, because if they can't come up, get the financing, then the buyer's not going to be able to close. Next one, leaving room for retrades. I think this just goes back to having a detailed versus undetailed LOI. If you have, or it could be unrealistic assumptions in an LOI. Sometimes these LOIs have, hey, here's the purchase price and terms, and it's based on these assumptions, and there's a bunch of assumptions put in there. Some of those might be unrealistic assumptions, and if that's the case, that's something the seller should look out for, because if those assumptions aren't met, which they may not be met because they're unrealistic, then that's going to open the door for that buyer to say, all right, we're going to retrade this, or hey, we assumed this in making the purchase price, so now that that's not true, we were going to offer this actually instead. So that's another one. And then leaving out key terms, key terms, deal breaker terms. I think some, the biggest ones obviously are structure, purchase price and terms, the financing terms, how that's going to work, and how the note is structured. Other deal breaker terms that I see is seller notes that are subject to offset. in my mind, buyer is going to typically ask for the ability, if there's a breach of reps and warranties and indemnification provisions, that they can offset the seller note if there is one. And if that's not in the LOI, that's going to be something that I think is going to be a hard fought issue later. So those are some of the key terms. I think, the big one, I went through the binding and non-binding provisions. So hopefully that kind of addressed what I think are the key terms. It's just really, what are the deal breakers for each party? And so that's the individual aspect of this. That's why it's not a cookie cutter approach. I think you really got to think of what the deal killers are. So other deal killers might be, management sticking around. So it could be something that, hey, I'm as a buyer, I'm evaluating this business and I'm willing to buy it, but only if, XYZ person agrees to an employment agreement to stick around. Now, obviously, the employment agreement doesn't force anybody to work for you. They can quit at any time still. But at least it's an employment agreement that gives them incentive to stick around, and you want to make sure that they're going to be, and maybe it has sticks involved in that employment agreement as well, like non-compete provisions and things like that. To the extent you can have those and they're legally binding, those might be things that will help a buyer understand or know that that person is going to stick around. And especially if they're a key employee that you wouldn't buy the business if they were going to quit the day after you bought it. That might be a key provision. So those are some of the things I see as deal breaker items that you want to have in there if it's important. All right, let's see, potential pitfalls. All right, we already went through that. All right, so I think we got through it. We a little bit over time, 12:42. Are there any other questions that I can answer at this point? All right, well, if seeing none at this point, thanks everybody for joining. This was a quick whirlwind tour of letters of intent. Hopefully you got some value out of it. Again, we're here at Doherty Legal are here to help with any sort of M&A transaction. That's what we do. And so feel free, if you have questions about LOIs or M&A deals or anything, reach out to us and we'd be happy to talk with you about it. All right. Thanks, everybody. Have a great day.